Ready, start. Through the judgment of the case, Aman Bhatia versus State GN City of Delhi, delivered on May 2nd, 2025, Justice J.B. Pardiwala and Justice R. Mahadevan have at the Supreme Court declared that stamp vendors across the country, by virtue of performing an important public duty and receiving remuneration from the government for the discharge of such duty, are undoubtedly public servants within the ambit of Section 2 subsection C1 of the Prevention of Corruption Act para. In the case at hand, the appellant was eligible for receiving discount on the purchase of stamp papers owing to the license he was holding. Further, the discount is traceable to and is governed by the 1934 rules framed by the state government. Thus, the appellant, without a doubt, could be said to be remunerated by the government for the purposes of Section 2 subsection 1 C of the PC Act para. The appeal in this case arose from the impugned judgment and order passed by the Delhi High Court, by which the High Court dismissed the appeal filed by the appellant herein and thereby affirmed order and judgment by the special judge on January 30, 2013, holding the appellant herein guilty of the offence under sections 7 and 13, subsection 1D, read with section 13, subsection 2 of the PC Act para. The trial court held the appellant stamp vendor guilty of the offences with which he was charged and sentenced him to undergo RI for 6 months and fine of rupees 1000 for the offence punishable under section 7 of the PC Act, and RI for 1 year and fine of rupees 1000 for the offence under section 13 subsection 1D, read with section 13 subsection 2 of the PC Act para. The High Court answered the question before it in affirmative, holding that ensuring access to stamp papers which are indispensable for legal transactions falls within the scope of performance of a public duty. The said public duty vending of the stamps is a licensed activity regulated under the statutes governing the sale of judicial and non-judicial stamp papers. The High Court further held that the fact that stamp vendors purchase these papers at a discounted rate before selling them to the public does not diminish the public nature of duty they perform. Para. The High Court added that in terms of explanation 1 to section 2 of the PC Act, it is not necessary for the stamp vendor to be appointed by the government in order to be a public servant. Para. The High Court also pointed out from the Rule 28 of the Delhi Province Stamp Rules stipulates the conditions governing the grant of license to a stamp vendor, and violation of the said rule would amount to an illegal act. Further, Rule 28 subsection 20 states that the remuneration of the vendor in the form of a discount is allowed from time to time by the orders of the local government. The High Court further took note of Rule 34, which provides for remuneration of stamp vendors by entitling the licensed vendor of stamps to discount on the amount of purchase. Para. From the reading of the Rule 34 subsection 2 and 34 subsection 3 of the 1934 rules, the Supreme Court had reached the conclusion that what is paid as commission to the stamp vendors is a discount at the given rate on the stamps purchased, and the same is treated as a commission. Presumption under Section 20 of the PC Act is drawn only cause the offence under Section 7 and 11 respectively, and not cause the offence under Section 13 subsection 1D of the PC Act. The presumption is contingent upon the proof of acceptance of illegal gratification to the effect that the gratification was demanded and accepted as a motive or reward as contemplated under Section 7 of the PC Act. Such proof of acceptance can follow only when the demand is proved para. In that case, the prosecution evidence alone cannot be considered for the purpose of coming to the conclusion. The evidence laid by the prosecution and the suggestions made by the defense witnesses, if any, are also required to be considered. It is then to be seen as to whether the total effect of the entire evidence laid before the court is of a nature by which the only conclusion possible was that the public servant accepted the amount. If the answer in affirmative, then alone it can be held that the prosecution established the case beyond reasonable doubt. Para. Undoubtedly, the presumption under Section 20 arises once it is established that the public servant accepted the gratification on examination of the entire evidence. The Supreme Court is of the opinion that the prosecution has failed to establish beyond all reasonable doubt the demand of bribe and its acceptance in a trap laid by the ACB. Hence, there is no question of presumption under Section 20 para. The legislature has used the comprehensive definition of public servant to achieve the purpose of punishing and curbing of growing menace of corruption. Keeping this intention of legislature in mind, the Supreme Court is of the view that the definition of public servant as defined under the PC Act should be given a purposive and wide interpretation so as to advance the object underlining the statute. It is a nature of duty being discharged by a public person which assumes paramount importance when determining whether such a person falls within the ambit of the definition of public servant as defined under the PC Act para. The prosecution has failed in establishing the allegation of demand for illegal gratification and acceptance thereof beyond reasonable doubt. Therefore, the conviction of the appellant for the offences under Section 7 and 13, subsection 1D, read with Section 13, subsection 2 of the PC Act, cannot be sustained and is thus liable to be set aside para. In the result, the appellant has been successful as the Supreme Court has allowed his appeal. The court has set aside the conviction and sentence of the accused as awarded by the trial court and affirmed by the Delhi High Court.